Of this screencast is to read the Dred Scott decision, which is source number 2 for some of you. To preview quickly, the Dred Scott decision is the title. Here's a picture of Dred Scott. We have a map of what America looked like at the time of the decision, which shows green are free states where slavery was not allowed, and the blue are states where slavery was allowed. And as the U.S. expanded west, it was determining whether this new yellow territory would become free or slave. That became a very heated battle. And it looks like 2 judicial bombshells, so we're going to get some court cases. So here we go. On March 6, 1857, Chief Justice Roger Taney prepared to deliver the most important decision of his career. Nearly 80 years old, the Chief Justice had long been opposed to slavery. As a young Maryland lawyer, he had publicly declared that slavery is a blot upon our national character, and every lover of freedom confidently hopes that it will be wiped away. So, this Judge Taney, this Chief Justice Taney, was against slavery. True to his words, Taney had gone on to free his own slaves, or enslaved people. Many observers wondered whether he and his fellow justices would now free Dred Scott as well. 2 judicial bombshells. The Chief Justice began by reviewing the facts of Dred Scott's case. Then he dropped the first 2 judicial bombshells. By a vote of 5 to 4, the court had decided that Scott could not sue for his freedom in a federal court because he was not a citizen. Nor, said Taney, could Scott become a citizen. No African American, whether slave or free, was an American citizen, or could ever become one. So, first bombshell is that Scott's not an American citizen, therefore he can't even take anybody to court. So it makes kind of the proceedings worthless in the first place. Next, Taney dropped bombshell number 2. The court had also rejected Scott's argument that his stay in Wisconsin had made him a free man. The reason was simple. The Missouri Compromise was unconstitutional. So, in this particular bombshell, he's saying this Missouri Compromise, which was deemed unconstitutional, and therefore the fact that Scott's in there as a free man, or the fact that Dred Scott's in Wisconsin, does not make him a free man. Taney's argument went something like this. Slaves are property. The Fifth Amendment to the Constitution says that property cannot be taken from people without due process of law. That is, a proper court hearing. Banning slavery in a territory, Taney reasoned, is the same as taking property away from slaveholders who would like to bring their slaves into that territory. And that is unconstitutional. Rather than banning slavery, Congress has constitutional responsibility to protect property rights of slaveholders in a territory. So, just like you might take your car from state to state, it still is your car. The same goes for enslaved people. If you go from one state in the south to Wisconsin, which is in the north, that means that even though you take your property with you, it is not taken from you just because you moved into free territory. The Dred Scott decision delighted slaveholders. They hoped that at long last the issue of slavery in the territories had been settled and in their favor. Many Northerners, however, were stunned and enraged by the court's ruling. The New York Tribune called the decision a wicked and false judgment. Another New York newspaper expressed outrage in its bold headlines. The decision of the Supreme Court is the moral assassination of a race and cannot be obeyed. So as we see, this court case was dividing the nation. People in the South thought, great, now the country's backing the fact that we can have enslaved people as property. And in the North, it got people very upset because they looked at it as a moral wrong. This ends the screencast.